He's our group member. Today we're gonna talk about the Rogers versus Whittaker case in 1992. This is an appeal court from the Supreme Court. The judges of the court were Mason, C.J., Brennan, Dawson, Toohey, M. Hill, J.J., and Galdron J. So the case about Mrs. Whittaker. She was nearly blind since she was knifed by an accident. In 1983, she met Dr. Rogers and he suggested her to have the surgery to check up her right eye and remove the scar. But unfortunately, after the surgery, her right eye didn't improve, but it led to the left eye developed inflammation and symptomatic ophthalmic and led to completely lost the sight and made she almost blind. She blamed because of Dr. Rogers, who did not advise her about the risks, and this was one of the reasons why it happened to her. However, even she had the misfortune, she's still trying to live her life. She finished her school, entered the workforce, married her husband, and raised her family.
So this case is the negligence case. Applying negligence law, the person is only liable to harm that is foreseeable consequence of their action. That is, their failure of exercise reasonable care and skill. In order to succeed in the negligence action, the plaintiff must acceptably on the balance of probability that the defendant owed them the duty of care. The defendant breached the duty of care to them, and they suffered the damage as a result of the breach. The duty is a single comprehensive duty covering all the way in which a doctor is called upon to exercise his skill and judgment. In the case Saraway vs. Juggernaut of Bethlehem Royal Hospital in 1985. In this case, the parent is an ophthalmic operation, a doctor, and the respondent is a patient. This is a nature doctor-patient relationship. In his position, Dr. Rogers has a liability to care to the respondent. In this case, in the operation, the condition does not always lead to the loss of vision. But the fact is, the apparent has not noticed the respondent about the risk that the surgery of the right eye could affect to her left eye. Therefore, the apparent has breached the duty of care. He failed to advise and warn the respondent of the possible danger of the operation. To answer for the question, has the apparent suffered damage? Apply the rule of legitimacy. The plaintiff must suffer some loss or damage as a result of the defendant's breach of duty. In this case, after the conduction surgery of the apparent, the respondent was from only lost from the sight from her left eye, become almost totally blind. The fact that the various opinion insider, if the patient asks a question concerned about the risk, would make the doctor aware that if the patient did in fact attach significance to the risk, the question would therefore require a truthful answer. Even though, according to the trial judges, the respondent did not ask specific question whether the surgery on her right eye could affect her left eye, but she already asked the apparent to make sure that nothing happened to the left eye one day before the surgery. So the evidence that the respondent has curious about her left eye, the trial judges agree. Proper practice requires the respondent be warned of the relevant risk.
Now I'm going to talk about the scope and the content of the lodger's duty of care. In this case, in order to figure out the best solution to judgment, the appellant argued that Bourne principle should be applied. According to Bourne principle, also similar doctor give a different practice. If the doctor acts in accordance with a practice accepted at the time by a responsible body of medical opinion, which means not negligent. On the other hand, the therapeutic privilege should be considered. In some situations, if the doctor tells the patient whole truth, and the patient will believe that the exposure of a risk would provide damage to a patient, so the doctor is not a breach duty of care.
By High Court decision, first the breaking of standard of care by saying the standard of care to involve the person with some special skill and competence instead of the ordinary skilled person exercising and professional. To have a special skill, that standard is not determined solely or even primarily by referring to practice followed or supported by the responsible body of opinion in the relevant professional of trade. Second, peer professional opinion by saying, particularly in the field of non-disclosure of risk and the provision of advance the information, the Bourne principle has been discarded and instead the court have adopted the principle that where evidence of acceptable medical practice is useful guide for the court. It is for the court to adjudicate and what is appropriate standard of care after giving weight to the paramount consider that a person is entitled to make his own decision for his life. The last one is breaking of duty to warn or risk by saying the law should recognize the doctor have the duty to warn a patient of the material risk insert in the proposed treatment. A risk is material if and the consisting of the particular case. A reasonable person in the patient position, if wanted of the risk, would be like to attach a significant to it, or if the medical particular is not reasonable to aware that is particular patient, if wanted of the risk, would be likely to attach a significant it to be. So by this reason, the High Court is dismissed a peer court.
Hello everyone, my name is Lee. Today I will talk about the conclusion. Medical practitioners and the patient. Medical negligence probably is very hard to identify. Until today, still often happen on the world. However, in this case, Roger and Vitus 1992, it is not the first medical negligence case happened on Australia. Nevertheless, this case is very meaningful in this history because it clearly shows the obligation of the medical practitioners identify the right and responsibility between medical practitioners and patients. The fact, doctors with the common practice haven't talked to the sickness to risk because the right risks are less than 1/100,000. So does not want to affect the body and mind of the patient. However, for this court, this right and obligation to determine this is the medical negligence, meaning setting the standards rules for the medical negligence case to judge, and given the significant spot for the future law modification. Finally, from above information expressed the responsibility of the medical practitioners and patients more extend from all walk of life to make a decision according to the provide information, take a non-negligent risk, and understand the work responsibilities.